If I'm honest, I've been in data protection now for 30 years, and if you're in data protection for 30 years, you too can look like me. And what I'd like to do today is just basically, very quickly, in 20 minutes, 25 minutes, is to give you just a sort of overview of where to find stuff and what are the major issues. What's the parliamentary timetable like? Well, the second reading is the first week in February, I understand, 7th of February, something like that. And of course, the thing is, the government have basically put a leisurely timetable to it. And the reason why it's a leisurely timetable is that there's opportunities to contact government if something's been missed out. Okay? Now, one of the things I'm going to encourage you to do is look at the data protection bill at the moment and find out where things are, because that won't change. The text might have minor tweaks, but the big things are set in stone. Right, okay, so the timetable is out of the House of Commons, then back to the House of Lords. It's going to be an interesting time politically, because I can't think of a much better time to have something about Europe trundling through the House of Commons. So that's it. If the worst happened, and I'll just say, if the worst happened and the whole thing collapses and there were to be a general election, normally there's a wrap-up session. There's a wrap-up session. And I would expect the GDPR bill, the data protection bill, to be part of the wrap-up session. The main reason for that is if we have to swan off and have a general election, we're not going to meet the 25th of May deadline, and the result would be that there'd be no derogations in the data protection regime. We'd have no data protection regime, the regulation would have direct effect, and there'd be no derogations at all. So what I want to do now is just give you an idea of what to look at. Right, here is the bill. 250 pages. Here is the regulation. Have you noticed something? Yeah, right, okay. You'll need to look at that. And there's something called a Keeling schedule for the data protection regime. Now, just to understand what's going on here, the problem the government has is how do we get a determination of adequacy? Now, normally, the UK government will basically legislate in its own particular way. However, how to convince those Europeans that we've incorporated the GDPR properly? Well, what we do is incorporate the GDPR, some of it, yeah? Some of it in relation to the main substantive parts in relation to data controllers and data processors. So this is what you need. Keeling schedule, that's the guts of what controllers and processors do. And essentially what you need to do is Google. Keeling is a Victorian civil servant, if anyone's interested. But anyway, Google Keeling, GDPR, and you get this. You still need the regulation. The reason for that is that the recitals of the regulation are what the data protection authorities are going to use when they interpret the GDPR. So basically, half the GDPR, the recitals, I think you need to look at. And in relation to the bill, you do not need to print off 250 pages. All you're interested in is part 1 and part 2, and that runs to 20 pages. So that contains the definition of personal data and how the data protection regime has effect, and schedules 1 to 4. Schedules 1 contains special personal data, sensitive personal data, rather like the Schedule 3 grounds of the 98 Act. And Schedules 2 to 4 contain all the exemptions. Now, the point I'm going to say is everything in the Data Protection Act is in the Data Protection Bill, so there's got to be a where's Wally. And I've got a few slides where to find Wally, okay? Some of you must remember that you're subject to the Law Enforcement Directive. Yeah? So, for example, law enforcement, local authorities have prosecution, in relation to electoral roll, housing, all sorts of minor things, trading standards. The prosecution goes with the law enforcement arrangements. So let's take, for example, the electoral roll, collecting the electoral roll, GDPR, prosecuting for breach of the electoral roll conditions, law enforcement. Housing, GDPR, prosecution of subletting, law enforcement. Okay, so you need to basically look at that. And then essentially Schedule 7 and 8 as well. So if you have a law enforcement function, you need to look at the law enforcement parts. And remember, make sure you're using the right regime. Just want to go through the major differences of the Data Protection Act. So you've got to know them very quickly. Some of them has been mentioned by Stacey. Personal data is, should we say, is much wider. It's much wider because identification of the individual is not necessarily by the controller. If you look at the data protection regime, the current Data Protection Act, the identification of personal data has to be by the controller. So just to give a sort of simple example, you've already had, you've all had the address labelled the occupier, 55 Akeka Avenue, from an estate agent. And no doubt the estate agent, practically wrongly in my view, but no doubt running this argument, saying, I haven't got personal data because I don't know who lives there. Okay? So his argument is because identification is by the controller, it's not personal data when he sends the letter out. However, if I asked you the question, if I gave you a database of addresses, would you be able to find out who lived there? The answer is, so I've got personal data. The estate agent would have personal data. So identification can be by somebody else other than the controller. So where you have location data, address type data, vehicle registration marks and things like this, that is likely to be through fringe things that you thought, is it, isn't it, under the Data Protection Act? Yes, it is, under the bill. Filing system. Now, I'm going to exclude social work, housing, education, because they've got accessible records. Filing system definitions changed. At the moment, for example, HR records or housing benefit records, if they were manual, the definition of filing system under the current Data Protection Act is relevant filing system, a filing system relevant to the Data Protection Act, which has to be highly structured. The filing system definition of the GDPR just means it has to have a structure. So, for example, I have a box file in name order and stuff in the box file in random order. And assume it relates to the same individual, okay? Right, so under the Data Protection Act, that filing system had to have a high degree of structure. Under the regulation, it doesn't. It's caught. So you might find some manual filing systems going from no data protection, or your public authorities, right of access and correction because it's category E, very little data protection to full data protection compliance with all the data protection principles. So one of the things you need to look is the manual filing system arrangements, okay? Consent, I'll go further than Stacey. Consent, I wouldn't touch with a barge pole for your functions. It could work on fringe things, like, for example, being on the museum support list, or I want to know when swimming lessons are available. Fringe things, consent, yes. Main things, no. Public task has been widened. And if you look at, say, Schedule 2, Paragraph 5 of the current data protection regime, functions, there's a sort of a limited set of functions that you can do, or a limited set of options for processing personal data. That's been widened under public tasks. So it's going to be easier to basically substantiate that the processing is necessary for your public task or your official functions. Balance of interest. don't use it for official tasks. However, it is available for other things, like, say, for example, HR. Balance of interest is still available there. No, that's Stacey. Transparency, just to explain this. Under the current Data Protection Act, the data controller has to identify the purpose of the processing and the data controller, and anything else which is necessary to guarantee fair processing. So notice it's in the gift of the data controller to identify what to tell data subjects. Under the regulation, it isn't. So retention times, legal bases for processing are public in a transparency notice, and there's going to be consequences for that. So if I say to you, I am processing personal data for a legal obligation, I'm processing your personal data for a legal obligation, what are you going to ask? What's the legal obligation? I'm processing personal data necessary for my functions. What's the function? Yeah? So essentially the transparency provisions are providing information to data subjects. And if data subjects disagree, they're going to find it much easier to argue with you. More rights for data subjects. Okay, there's a section on rights, I think I've read it. All I would say is the right of access is 30 days normally, but you can stretch it to 2 months if need be, for hard cases, okay? Some of the rights, right to be forgotten, I don't think will apply. Right to data portability won't apply. I think the other rights are probably manageable, except for the right to object. If you're processing personal data that's necessary for your functions, and the data subject objects to that processing, the burden of proof will be on you to demonstrate that your processing should continue. Now, for most organisations, it's not going to be a problem, and it's pretty useful. I mean, I get these letters from the HMRC, make demands for money and menaces. Well, I think I'll object to that. No, you won't be able to object to that sort of thing. But it's there to protect the individual just in case something happens. So let's say, for example, give an example. I'm processing, I have the facial characteristics of a crook, and your local authority has a CCTV system with facial recognition. And every time I walk down the main street, like the Pied Pipe of Hamelin, I have 5 coppers following me. Yeah? That's when the right to object is going to basically work, okay? Your systems aren't suitable enough, and that's the kind of thing where I'd expect the right to object to apply. Accountability. Now, this is a really big thing. If you look at the Data Protection Act, you'll find the principles. Personal data shall be adequate, relevant, not excessive. Kept no longer than necessary. And if you look at this principle 7, the interpretation of the 7th principle, you must make staff reliable. So it's stuffed of shalls and musts. Now, there's no requirement to keep evidence that you've done it. So if you haven't got evidence, it harms your defence. Harms your defence under the current arrangement. Under the accountability principle, if you haven't got evidence, you haven't done it. And that's a major thing that you need to look at. Okay? Personal Data Asset Register compilation, Article 30. How do you know what to protect unless you have a list of what to protect? That's basically the simple thing. So essentially that's an important element. Data processor relationship. Let's try this one on you. You're my data processor, and you've lost 5,000 criminal records in encrypted form. Unencrypted form, yeah? How keen are you on the scale 0 to 10 to tell me? Right, okay, now you'd understand why they've changed it. Some of the stuff that's in your contract, no doubt your contract says train your staff, report data losses. Some of the stuff comes out on explicit obligations on the processor. And what that means is that the Data Information Commissioner can go after the data processor if there's a data loss. All your contracts with data processors collapse on the 25th of May, midnight. And so basically you need to renegotiate them, certainly the big ones. Data protection officer, I don't need to do. Data protection by design is a consideration. Transfers to third countries. There's new rules on here. The current Data Protection Act allows you to assess adequacy yourself. That goes. And the penalties for transgression. Now, I've mentioned Brexit. I'll come back to Brexit right at the end. This is why we have a data protection bill. There are lots and lots of derogations from articles from member state law. Now, notice, no member state law, no derogation. So that's one of the reasons why, in a sense, you need to look at the regulation. And then, so we say, look at the derogations. Are they being incorporated into the UK regime? Because not all of them have. So just basically go through some of them. Okay. Definition of data controller. Controller that's got statutory obligations to process the personal data is the controller. The controller. Yep. So if there's a statutory obligation, you are the controller. So if you outsource, you're outsourcing to a processor. Consent of the child for information society services is 13. Health warning only for information society services, not for subject access. You've still got Gillick, Fraser competence to look at. Special personal data has been broadened, and there are more grounds in Schedule 1 for using them. So what's the extension? Sexual orientation, instead of, as well as sexual life. DNA, RNA, genetic information, but the one that might catch you is biometric in the context of identification. So essentially your security people, if they decide to have fingerprint recognition on laptop access, biometric in the context of identification is special personal data. Right to erasure, a lot of, should we say, modifications for research. Automated decision and profiling. If you're going to be profiling, you need to do it by law, otherwise you'll have difficulty. And there's lots of exemptions for important general interest, objectives of general public interest. Now just think of your poor monitoring officer. He's not had a subject access request, no subject access exemption since 1984. How has he survived? However, the regulation provides him one, okay? I suspect the government have gone round, all the public bodies said, psst, who wants an exemption? Of course, the Information Commission has got a new exemption as well, by the way, just to let you know. And of course, it's very difficult for them to challenge other people getting exemption if they have a brand new one themselves, okay? Supervisory authorities, a lot of controls are with the Data Protection Authority, the Secretary of State as to how the Data Protection Authorities work. Representation of data subjects. This is something the government are resisting. Okay, just flag it up. And it's going to be something that you need to monitor. Can NGOs raise issues without the need to be representing a data subject? Can they raise issues on their own? And the NGOs want to do that. The NGOs are the watchdogs. They want to bark. Government prefer them muzzled. So they've been resisting NGOs basically taking up cases independently of the data subject. Conditions for manual files. Now, the next thing I just mentioned, FOI, Data Protection Interface, is in Schedule 18 of this. Schedule 18 of this, right at the end. Okay? It's unchanged, more or less. And there's lots of stuff for research, which I'm not going on to. So basically what I want to do is just quickly do a where's Wally? Okay? Right. Now, these numbers relate to the bill as published at the House of Lords. Right, okay, so it's taken me around about 2 months to read the whole damn thing. And when it gets to the Commons, there's an extra 50 pages and lots of changes. So, but anyway, so there may be 1 or 2 out. Okay, right. The balance of interest, when you have a subject access request and you have information relating to another individual, you know that one? Yeah? That's an exemption now, and it's in Schedule 2, Part 3, Para 14. Yeah? Okay? Now, protection of health workers, social workers from basically people who might attack them. As you know, there's statutory instruments that give lots and lots of, should we say, protection at the moment. So, for example, even with respect to, say, disclosures of social work records to councillors or MPs, there are provisions. Now, all those statutory instruments go with the Act. And what the government have done is reincorporated them in Schedule 2 to 4. And that's the reason why it goes on for 40 pages. So that's the reason why you need to look at the stuff. Right, okay. Section 29(1), exemption for law enforcement, is in the law enforcement bit. Yeah, part 3. Okay, paragraph 43. Disclosures to law enforcement is Schedule 2, para 2(1). And when you read it, what you do have to do is take the word processing and substitute disclosure. So the exemption from the non-disclosure provisions, subject information provisions, so notice what do you provide the data subject, what do I do when I disclose, okay, they've gone, okay, they've gone, and what's in its place is basically processing for law enforcement purposes and prejudicing that purpose. So notice processing for substitute disclosure, you'll find that an exact exemption is reconstituted. Disclosures required by law, that's when you basically have to disclose information or exercising your powers. That's in Schedule 2, para 5. Legal proceedings, disclosing in relation to lawyers, voluntary disclosures, 5.3. You can read the list, right, okay? Yeah? Electoral roll, personal data made by law, domestic purposes. I've managed to put the main ones in, but the paragraph numbers might be out 1 or 2. Okay? So you might find that list helpful. So what are the final comments that I'll make? Okay. Everything in the Data Protection Act is in the Data Protection Bill. You need to find where it is. If it isn't there, look again. Right? If you still can't find it, you might need to contact the DCMS to say, hey up, you've missed an exemption or you've missed something. The CNIL, that's the French Data Protection Authority, has published data protection impact assessment software and guidance in English. A French commissioner publishing something in English. Does that sound a bit strange? Are you doing stuff in French? See? Right? Not reciprocal there. Right. The reason for this is quite simply, the head of the CNIL is going to be head of the European Data Protection Board once the regulation comes in. And guess which privacy impact assessment approach she will support. Give you a choice, A, the French, or B, the English. Take your time before answering that question. Right. So notice, have a look at it and see what you think of it and things like this. There is software. Working Party 29 documents now become incredibly important. Normally, they're basically for people who are in psychiatric help. You know, oh, yippee, there's 50 pages on consent. But the Working Party documentation now is the Working Party 29 is the European Data Protection Board in waiting. What they say counts, so please monitor that. Security. Look, and Mark Brett is here this afternoon. Local public sector data handling guidelines is being republished for April. Some of you are going to use the NHS toolkit, which has been renamed for some reason, okay? Social services, after all, Hunt is going, keep what social services, so notice social services is likely to amalgamate around these, so we say the NHS rules. And of course, the thing is, if you're connecting to the government, you still have the HMD security framework to worry about. But for the rest of you, local public sector data handling guidelines, if you haven't got a copy of it, do not rely on adequacy determination for the UK. Right. The government have introduced the text to basically get a degree concept of adequacy. I'm not 100% sure it'll work, so I'll try this on you. You're the European Commission. I'm the UK government. I'm saying, sod off. We're going to our own way and make trade deals with President Trump so we can get chlorinated chicken and things like this. So sod off, we're not paying any money to you. As I go out the door, I turn around and I say, can I have an assessment of adequacy, please? And your response is? Right, so notice what I'm trying to say to you is find out what personal data goes from Europe to you, because they are the ones at risk if Brexit goes pear-shaped. Now, do you trust the politicians? So you might need to have plan B. Okay, and just to say, Stacey, no mega fines for a year, at least a year. However, what I would say is, if the breach would have been a breach of the current arrangements, I don't think you'd have much sympathy. Right, okay, my company is Amberhawk. I forgot what I said. What we do is we take normal people off the street and turn them into data protection officers. And essentially that's that.